It is a fact that 1 in 4 of us will have difficulties with our mental health at some point in our lives, and in some cases things can result in admission to hospital. Now, the law does permit for compulsory admission to hospital for assessment and for treatment, and the main piece of legislation which deals with admission to hospital is the Mental Health Act 1983. So if you or a relative are detained under the Act, then TV Edwards has an experienced mental health team, and we can advise you on your rights and provide representation. Legal aid also is available in such cases. People can end up in a mental health hospital in a variety of ways, but usually people are admitted directly from the community following assessment from the mental health services. So they would usually have come into hospital after having seen 2 doctors and an approved mental health professional, and those professionals would have all been of the view that the person requires admission to hospital. Use of a section is considered where either the person declines voluntary admission, or they lack the capacity to consent to voluntary admission, or where the hospital would not be able to properly manage or treat them without the section. So other sections include a community treatment order, guardianship, and what are known as forensic sections, where a person is sent to hospital through the criminal justice system, so they've been admitted either via the court or through the prison service. Patients who are detained under the Mental Health Act do have certain rights, and in particular can challenge their detention in a number of ways. Patients can appeal to the Mental Health Tribunal, and the Tribunal is an independent judicial body which is made up of a judge, a consultant psychiatrist, and a third specialist member. The Tribunal would have a hearing in hospital where the Tribunal will consider reports written about the patient, hear evidence from the care team and from the patient, and then they will decide whether the patient still meets the legal criteria for detention. The Tribunal does have the power to discharge the patient either immediately or on a deferred basis, and also they can in certain circumstances make certain recommendations, for example regarding leave, transfer, or discharge onto a community treatment order or guardianship. Patients can also request that their detention is reviewed by the hospital managers, and this can be done at any point. The hospital managers who consider these kind of cases are not involved in the day-to-day running of the hospital. However, they do have special training in the Mental Health Act, and they have the power to discharge a patient where they are of the view that detention is not required. The nearest relative does have a special role under the Mental Health Act. In the case of a patient who is detained under Section 2, the nearest relative must be informed of the patient's admission to hospital. For those patients who are detained under Section 3, then the nearest relative must be consulted, and it's very important to note that admission under Section 3 cannot proceed where the nearest relative objects. Once a patient's been admitted, the nearest relative does have the power to discharge the patient. If they want to do this, they have to give the hospital at least 72 hours notice, and this notice must be in writing. However, the responsible clinician can block the nearest relative's attempt to request discharge, but to do so, the responsible clinician must file a report setting out, in their view, why they feel the patient is likely to act in a manner dangerous to either themselves or to others. Now, if such a report is filed, then the hospital managers will consider whether to hold a review of the patient's case, and if the patient is detained under Section 3, once the Barham report has been filed, the nearest relative would then have their own independent right of appeal to the Tribunal. We know how stressful mental health law issues can be, not just for individuals but also for the friends and family. TV Edwards has a very experienced mental health team, and we aim to see all new clients within 24 hours. We can provide representation before the Mental Health Tribunal and also before hospital managers. We can also attend CPA meetings and discharge planning meetings, and we advise patients who have been treated in the community and patients who have been admitted through the criminal justice system. In addition, we can also advise in criminal cases where a person's mental disorder is an issue. We can advise on mental capacity issues and also on court of protection matters. If you require any advice or you would like to refer a case on to us, then please contact us via email, and the address is a_mentalhealth@tvedwards.com. Our telephone number, if you would like to speak to us, is 0203 440 8000, and please ask to speak to anyone in the mental health department.